Good morning. I am Dr. Ritu Gupta, Faculty, National Law University, Delhi. In today's module, we'll discuss about National Company Law Tribunal and National Company Law Appellate Tribunal, their constitution and duties. Let us have a quick overview of the module. The module focuses on the constitution, powers and duties of the National Company Law Tribunal, which was earlier known as Company Law Board, and National Company Law Appellate Tribunal. This module would provide an overview of the whole framework of the functioning of the tribunals as has been provided under Chapter 27 of the Companies Act 2013. In this module, we'll talk about sections 407 to 408, which provide for the constitution and qualifications of President and members of the tribunal, while sections 410 to 11 state similarly for the appellate tribunal. Further, sections 412 to 18 would be discussed that prescribe the procedure for selection and removal, resignation, the term of the office and salary, etc. of the members as well as the president of the tribunal and appellate tribunal. The place for the tribunal is provided under section 419, and further we'll talk about section 420, which talks about the orders of the tribunal. Then section 424 that provides for the procedure which should be followed by the tribunal and the appellate tribunal. The second appeal which may be filed with Supreme Court, section 423 we are going to talk about, and then we'll discuss section 425 to 432 that provide generally for various powers of the tribunal and appellate tribunals. Now I would discuss the objectives of the module. The main objective of this module is to provide preliminary knowledge about the National Company Law Tribunal and National Company Law Appellate Tribunal, to apprise the students of the constitution and the powers of the NCLT and NCLAT. Moreover, by discussing the contents of this module, we would make students understand the procedure of filing appeals, etc., as has been prescribed under the Companies Act 2013. Now I would introduce you to the contents of the module. The new Companies Act confers powers on the central government to constitute National Company Law Tribunal and National Company Law Appellate Tribunal. These tribunals are quasi-judicial bodies that govern the companies which are functioning in India and administer the provisions of the Act. The present Act has replaced the earlier body known as Company Law Board (CLB). It would exercise almost similar powers that were being assigned to by the erstwhile Company Law Board. The constitution of one body, that is NCLT, has streamlined the administration of justice under the Act. It is intended to have greater expertise to adjudicate disputes more efficiently and expeditiously. The appeal from NCLT orders would lie with NCLAT. The second appeal may be filed with Supreme Court. The whole justice administration system has been made time-bound. The tribunals comprise of senior judicial and technical members, and these tribunals are not bound by the procedure as has been laid by the Civil Procedure Code 1908 and have the power to regulate their own procedures. These are to be further guided by the principles of natural justice, PNJs. Their orders are enforceable just like the decree of any court. Now let us discuss the constitution of National Company Law Tribunal, which has been provided under section 408. National Company Law Tribunal is a successor quasi-judicial body of Company Law Board. The central government is to constitute this tribunal that shall consist of a president and such number of judicial and technical members as may be deemed necessary. Such members are to exercise and discharge such powers and functions as may be conferred on it by or under the Act or any other law for the time being in force. Section 409 provides for the qualifications of President and the members of the Tribunal. The President shall be a person who is or has been a judge of the High Court for 5 years. To qualify for appointment as a judicial member, a person shall qualify any of the following. Can be a judge of a High Court, or it is or has been a district judge for at least 5 years, or has been an advocate of a court for at least 10 years. A technical member of the tribunal shall fulfill any of the following. He can be a member of Indian Corporate Law Service or Indian Legal Services, out of which at least 3 years shall be in the pay scale of Joint Secretary to the Government of India or equivalent or above in that service. A chartered accountant who has been in practice for 15 years, or a company secretary who has been in practice for 15 years. He should be a person of proven ability, integrity, having special knowledge and experience of 15 years in law, industrial finance, industrial management or administration, industrial reconstruction, investment, accountancy, labor matters or such other disciplines related to the management, conduct of affairs, revival, rehabilitation and winding up of the companies, or 5 years standing as a presiding officer of a labor court tribunal or national tribunal constituted under the Industrial Disputes Act 1947. Section 410 further provides the central government shall constitute an appellate tribunal to be called as the National Company Law Appellate Tribunal. It shall consist of a chairperson and members not exceeding 11. The central government shall notify such appointments. The appellate tribunal has to hear appeals against the orders of the tribunal. Further, section 411 states the chairperson shall be a person who is or has been a judge of the Supreme Court or the Chief Justice of a High Court. A judicial member has to be a person who is a sitting or retired judge of the High Court or judicial member of the tribunal for 5 years. A technical member has to possess the same qualifications as stated in the constitution of the tribunal. Section 412 provides for selection of members. The president of the tribunal, the chairperson and judicial members of the appellate tribunal are to be appointed with consultation of the Chief Justice of India. The members of the tribunal and technical members of the appellate tribunal have to be appointed on the recommendation of a selection committee. This selection committee shall consist of Chief Justice of India or his nominee, who will be the chairperson of the committee. Then we have the following members: Senior Judge of the Supreme Court or Chief Justice of a High Court, Secretary in the Ministry of Corporate Affairs, Secretary in the Ministry of Law and Justice and Secretary in the Department of Financial Services, who is in the Ministry of Finance. Further, the Secretary in the Ministry of Corporate Affairs shall be the convener of the selection committee. The said committee shall determine its procedure for recommending persons as we have just discussed. However, no such appointment of the members of the tribunal or the appellate tribunal shall be invalid due to any defect or vacancy in the constitution of the selection committee. Now let us discuss the terms of office and salary structure. Section 413 to 414 provide for it. The president and every other member of the tribunal is to hold office for a term of 5 years from the date on which he enters upon his office. He shall be eligible for reappointment for another term of 5 years. The age of retirement would be 67 years for the president, while that of the members is 65 years. The salary, allowances and other terms and conditions of service of the members of the tribunal and the appellate tribunal would be prescribed under the rules. However, we have to see that it is provided further that neither the salary and allowances nor the other terms and conditions of service of the member shall be varied to the prejudice of those who have been appointed.